class. So welcome to all of you. Excited to have you here today. Yeah, so I love teaching at SJCL. And one thing I love is that it is smaller, so I get to know our students really well. So wherever you end up going, whether it's law school, whether it's here, somewhere else, definitely encourage you to get to know your professors, go to office hours, come by, see us, because we're here because we really want you to learn, and you owe it to yourself to invest that time, invest in those personal relationships with each other and with your professors. So civil procedure is about the process of filing a lawsuit. We focus mostly on federal courts. So our case today is a federal case, and it's kind of the life cycle of the lawsuit. So we start the course with where to file a case in terms of subject matter jurisdiction and what state, what districts. And then we talk about service of process. We talk about what can be included in a pleading or a complaint, how much information, how to answer, what parties to join, counterclaims. Then we talk about discovery. And then we get into trial by jury, which is what we're focusing on today. So I'm going to share a PowerPoint. I might need to, oh, it looks like I'm already a co-host. So I'm gonna pull it up for you guys. Just 1 second. And let me put it in slideshow mode. Going a tiny bit slow, I'm not sure why. Okay, so starting with the right to trial by jury. Can everyone see it okay? Let me see.
Yes.
Okay, let me see, is it doing? Okay. 1 second. Mine's doing like a weird thing. Okay, is it showing you like just the front side, or not the like side panel thing?
You can still see the slide panel.
Let me see. How do I do it in the regular mode? I usually am up in our classroom and I'm not today. Let me get it in slideshow mode for you guys. 1 second.
Logan, if it makes any difference, you can't really read the side panel, so it probably wouldn't be a problem.
Okay, cool. I'll just go with it. Everyone can see the text. Okay, it's like big enough.
Yeah, on the main slide.
Okay, cool.
I mean, so far, yeah.
Okay, so let's start with trial by jury in general. So the United States holds 80% of the jury trials in the world. And we're one of the only countries in the world that still has trial by jury in civil cases. So even countries that have criminal jury trials, a lot of them don't in civil cases. So I'm sure a lot of you, since you're interested in law school, have watched, some of the big trials in our lifetime. So Johnny Depp and Amber Heard was a civil trial that a lot of people paid a lot of attention to, and that we use some examples of in civil procedure. So if you ask yourself, why is this case in Virginia when both of these people live in California? That's something that we talk about related to personal jurisdiction in my class. But jury trial comes up 4 different times, or 5 different times actually, in the United States Constitution. So you have 2 quotes here, one from Thomas Jefferson and one from John Adams. So the Thomas Jefferson quote says, "I consider the trial by jury as the only anchor ever yet imagined by man, by which a government can be held to the principles of its constitution." And then John Adams, "Representative government and trial by jury are the heart and lungs of liberty, Without them, we have no fortification against being ridden like horses, fleeced like sheep, worked like cattle, and fed and clothed like swine and hogs. So I know this all sounds dramatic, and we have two of our founders, one an anti-federalist, one a federalist, but both talking about how important trial by jury is. So why do you think this was so important to the founders? Any guesses?
Logan, I don't know if it's just my screen, but it's still only on the first slide, mock law class.
Oh, okay, here.
I'm not,
Let me
is,
see.
are other people seeing the next slide?
Is it changing? Let me see. My screen is kind of like frozen. Let me just try it again. 1 second. Okay. So any guesses about? Let me see here. Okay.
Now that's perfect.
Okay. Now you can see the quotes.
Mhm.
Okay. So any guesses about why trial by jury was so important?
If I remember my history right, before the founding of the country, it was really up to kind of the whims of like the king and like the magistrates instead of the people.
Yeah, so under British rule, Americans didn't have a vote. So that's where we get the no taxation without representation. So jury trials were really the only voice of the people. So it was the only way that the colonists had to disagree with laws to, for instance, like if you're talking about seditious libel, so it was illegal to say anything negative about the crown, even if it was true. But if there was a trial against someone for printing materials, they could nullify. It was the only way they had any real power. So it was important to them because it was their tool against tyranny, their way to prevent abuse by the government. So for you to lose your liberty in a criminal trial, all three branches of government have to be involved because Congress has to pass a law if we're talking about a federal criminal trial. Then it has to be enforced by the executive branch. Then you have to have a trial in, the judicial branch. And then you have the voice of the people, right? So in addition to the three branches, you have actual fellow citizens. So this was considered to be extremely important. So it comes up, has this switched for you guys to the third slide now? Is it showing the Constitution? Okay, so it comes up in Article 3, and it comes up in the Bill of Rights. So it comes up in the Fifth Amendment, talking about grand juries, the Sixth Amendment, talking about juries in criminal trials, and what's relevant for our purposes, the Seventh Amendment, which talks about trial by jury in civil cases. So the Seventh Amendment preserves the right to trial by jury in cases at common law. So what that means when we talk about preservation is that they preserved the system as it existed in England, where there were basically two different court systems. One were called courts of chancery or courts of equity. And for those courts, there was no right to trial by jury. So equitable cases are cases for an order. So say in order to stop using someone's trademarked materials. That type of case, there's no trial by jury. But cases at common law were cases for money damages. So if you sue someone after a car accident or for breach of contract or for wrongful death or assault or for a property dispute and you're asking for money damages, then there's a right to trial by jury. So Edmondson's case, when we talk about our case, is a case at common law because what is he suing for? Does anyone remember? Why is he suing Leesville Concrete?
For damages for a injury from a workplace accident.
Yes, he's a construction worker. He is manufacturing concrete and he is injured on the job when his leg is pinned between like 2 tons of concrete, and he is suing for lost wages and for medical bills. So under the 7th Amendment, he is entitled to a trial by jury because he's suing for money. So the 7th Amendment preserves that. So because it's a right, it can be waived like any other right. So why might someone waive their right to have a trial by jury?
Because they want it to go faster.
Yes. So jury trials are expensive and they are time consuming. So selecting the jury deliberations, all of those things add a lot of time. And when you're paying your own attorney, because we're talking about civil cases, so there's no public defender, you have to pay your lawyer unless someone's, giving pro bono services. That means you're spending more money. Any other reasons?
I think depending on the case, you may get more, it may be more favorable to have a judge decide than lay people.
Yeah, so you could have a really complex case about, patent litigation, and you might want someone with more expertise on that area of law than your average juror. So for complicated matters, the parties might prefer to have a judge instead of a jury, even if there's a right to trial by jury. And in some cases, depending on the community someone lives in, they might think that, a jury is actually going to be more biased, even though a jury is supposed to be a jury of your peers, drawn from a reasonable cross-section of the community. There could be some communities where maybe based on coverage of the dispute in the paper, or maybe based on the demographics of the community, they might think a judge would actually be less biased, would be, more open-minded about their case than fellow citizens. So sometimes, there are various reasons someone might want to waive the right to trial by jury. And there are some studies that suggest that most times juries and judges reach the same conclusion anyway. So, just like Brittany said, might be more efficient. Juries can also be a lot less predictable. On the other hand, someone might want to have a trial by jury because jurors are everyday people. So unlike a judge, they usually haven't gone to law school. Once you go to law school, you will probably not be selected for a jury. So before you start, if you get the opportunity to serve on a jury, I encourage you to do so because that probably won't happen for you after law school. And so they might be more understanding of a party's life experiences, and you have more of them. You have 6 to 12 people. So even if one has some biases, we might think their decisions about the facts are more reliable because you don't just have one person, you have a lot of people looking at the facts. They might be more sympathetic to certain plaintiffs. So personal injury, med mal, class actions, juries are often known for giving higher damages. And in civil rights cases, having a jury can raise public awareness and increase public buy-in and trust in the judicial system. Plus, there's more control. So that's what we're going to talk about. We're going to talk about how the parties can control who ends up in the jury. Because you get assigned a judge, you don't get to use a peremptory challenge to get rid of your judge. But there is some power of the parties in selecting jurors. So while the phrase a jury of one's peers isn't used in the Constitution, it has been considered since the signing of the Magna Carta to be part of the essential right to trial by jury. So at the time, it meant a jury composed of fellow nobles, not just the king, but now it means a jury of fellow citizens. So there are two basic parts of jury selection. The first is called the venire, and that means who is called into the court, who is summoned, who might potentially be part of the jury. And the second part is called voir dire, and that's of those people in the venire who is actually selected. So for the venire, they have to be drawn from a representative cross-section of the community. Does this mean that, let's say we're looking at Thaddeus Edmondson, does that mean that today there has to be another Black American juror in his jury if he was filing this case today?
No.
No, right? It doesn't mean that anyone is guaranteed a jury that has any members who share any characteristics with them, right? If I was filing a case, it doesn't mean that I'm going to get another woman or another person who has my same job or another person who is a mom, right? Doesn't mean that we're guaranteed anyone on our jury who shares any of our characteristics. But it does mean that the venire has to be drawn from a random representative cross-section of the community. So what qualifications are there to serve on a jury? So in federal courts, you have to be over 18. You have to be a United States citizen. So in Fresno, I don't know how many of you are local, but in Fresno, we have, a large immigrant population who might be visa card holders or might be lawful permanent residents, but might not have gotten US citizenship yet. So if the party is not yet a US citizen, that automatically means none of the people on their jury are going to be fellow immigrants who haven't attained US citizenship yet, right? Just by definition. You have to have resided in the judicial district for at least 1 year, must be able to speak, read, and write in English, must lack mental or physical infirmities that would make you incapable of jury service, and must not have been convicted of a state or federal felony. So already we have this criteria where if by mistake someone is summoned to the venire and they say, I've only been in the judicial district for 6 months, they're going to be excused by the judge. And no party is going to have to use a peremptory challenge or challenge them for cause. The judge is just going to excuse them. So the way the process looks is that the court mails a preliminary questionnaire to try to determine eligibility. And generally they use registered voter lists or driver's license lists. So registered voter lists, throughout history, when Black people and women were denied the right to vote, they didn't have to use peremptory challenges as a tool to try to exclude people, because by not giving people the right to vote, they had juries that were composed only of white men, right? That was the way that juries were kept, to just male and just white. But as the right to vote has expanded, peremptory challenges have come up, and sometimes oftentimes there has been cases of them being used to keep people off of juries based on their race, which is what comes up in our case today. Then people are sent a summons to appear in a specific case. They are randomly selected. Once they arrive, they fill out another questionnaire, and then the process of voir dire starts. So there are two ways that a juror might be stricken during voir dire. One is for cause, and this is the actual federal statute. And one is a peremptory challenge. So does anyone remember from the reading, what is the difference between these two types of strikes?
I remember something about the preemptory challenge. And it was that attorneys didn't have to explain their reason or justification for it, that they were allowed it free of explanation.
Yes, they are used without giving any reason at all, whereas a for cause challenge is for a particular reason. So it could be that the juror is not qualified in some way, they don't meet the criteria, or it can be for some type of bias. So there has to be a legal basis. So the bias can be actual bias or implied bias. So implied bias arises when the average person in the juror's shoes would be unable to be impartial, even if they say and they honestly believe that they could be impartial. So for example, if I say, you know what, the defendant or the defendant's lawyer is my brother, but I think I can be objective in this case. Even if I really believe that, I am going to be struck for cause, not because I'm lying, but because the average person couldn't be impartial if their brother was the defendant or the defendant's lawyer. Same with if they have read a ton about the case or they have been a party in a identical case against the same defendant, or if they have a financial stake in the outcome of the case. Let's say I own a ton of shares in Leesville Concrete and I'm on the jury. Even if I say, and I really think I'm going to be fair, I'm going to weigh the evidence, the fact is, I have a financial stake in the outcome of the litigation, because if defendant has to pay a lot of money to plaintiff, that will hurt my bottom line. So that is implied bias. Does someone have a question? Brittany?
I was curious, what if the jurors are like related, like husband and wife on the jury?
So that might be, that wouldn't be necessarily a reason for them to be struck, but the parties themselves might think, I'm going to use my peremptory on that basis because, maybe I'm worried. Oh, I think I'm not really sure that either of these people are going to be favorable to my client. And so, if they're discussing it by themselves at home, I don't want them to, influence each other or something like that. Yeah. So actual bias is when someone says, based on their beliefs, experiences, that they wouldn't be able to reach a particular outcome, or they couldn't believe a certain type of witness. So let's say you're in a state where marijuana is illegal and you have a juror who says, I could never put someone in jail for a nonviolent marijuana crime, right? Or in a death penalty case, someone says, I could never sentence someone to death, right? That goes against my beliefs. That's actual bias that can be the basis for a for cause challenge. And there's an unlimited number of for cause challenges. The other type of challenge is a peremptory challenge. So this is an actual bar exam question I wanted to give you guys if you want to take a shot at it. So a real question that has appeared on the California bar. So it's about for cause challenges. So I want to give you guys a minute to look at it. Anyone want to take a guess? And I'm not monitoring chat at the same time.
Chad is saying D. I agree with them.
Yes, you guys are right. You have passed your first, what they call MBE, which is multi-state bar exam question. The answer is D. So the bar exams have multiple choice, half essay, and the questions vary in difficulty, but the answer here on this one, again, real question, is D. So good job to all of you on that. This is an example of presumed bias. And we can rule out C because even if there weren't enough other potential jurors, more would have to be summoned because you can't be forced to have people who have, presumed bias or implied bias on your jury just because there aren't enough people. There would have to be more who were summoned in that particular instance. Yeah, our answer is D. So a peremptory challenge, on the other hand, comes up at the end. So on this timeline, if you are at this last block, a peremptory challenge comes when the lawyers or the parties, if they aren't represented, each get a certain number. In civil cases in federal court, each side gets 3, where they say, Judge, I'd like to strike juror number 17, and they don't give any reason whatsoever. So the question, right, that comes up in our case is, what does the other side do if they think that a juror is being struck through the use of a peremptory on the basis of that person's race? Is there anything they can do at all? So no reason is stated. And peremptory challenges, they don't come from any constitutional right, but they come from a federal statute, which comes up in our case. So prior to Edmondson versus Leesville, there was a case called Batson versus Kentucky that asked the same question, but in the criminal context. But before we get there, why allow peremptory challenges at all? We know jurors have already been struck for cause, so we're not worried about actual or implied bias. They've already been struck if they aren't qualified. Why should the system allow peremptory challenges, period?
I think despite their answers, the way they're presenting in court, the lawyer can have a hunch of they think the juror might be biased, regardless of them saying they're not. Just maybe, I don't know, they're crying during certain parts of it, or they're rolling their eyes.
Yeah, absolutely. If somebody's shaking their head, rolling their eyes, staring at their phone and scrolling through it, scoffing, right? While the lawyer's presenting, I'm going to think maybe this person won't be favorable to my client. Or let's say I'm a public defender and my client is, a young Black man, and one of the jurors has a ton of Make America Great Again clothing on. Maybe that person is going to be totally impartial to my client, but personally, my hunch is going to be, I might not want them to be on my jury. Maybe I'm wrong, but I probably am going to strike them, right? I could be totally wrong, but that's just going to be my hunch. And my duty as a lawyer is to be a zealous advocate for my client. It's to act on my hunch to try to get the best result for my client, right? Maybe that person hasn't said anything that shows actual or implied bias. And again, I could be wrong, but there are lots of reasons why I might think this person might not be the best person to be on this jury for my client, right? So that's the that's the good thing about peremptory challenges. That's their purpose. What is the drawback? What's the concern about a system that allows peremptory challenges?
It doesn't allow someone to participate in the legal system as a juror.
Yeah, and it can be used in a discriminatory way, right? So on the one hand, it allows people to be a zealous advocate. On the other hand, it has been used as a tool for racial discrimination and discrimination against women, discrimination in all sorts of contexts. So this is a 1964 prosecutor's manual that says you're not looking for any member of a minority group. They almost always empathize with the accused. It also said you're not looking for free thinkers and flower children. So actual published, manual. So this has been going on for a long time. So Justice Thurgood Marshall believed that ending racism in jury selection could be accomplished only by eliminating peremptory challenges entirely. And some states have done that. We're talking again about federal court. Some states don't use peremptory challenges in their state jury selection. So there are good things about peremptory challenges, but there can be drawbacks as well. So in Batson versus Kentucky, an African-American man was arrested for burglary. At trial, the prosecutor used his peremptory challenges to strike the Black jurors from the veneer. He challenged this, saying that it violated his right to an impartial jury and violated the struck jurors' rights under the Equal Protection Clause. And in a 7-2 decision, the Supreme Court agreed with Batson and held that the state, meaning the prosecutor, cannot use its peremptory challenges to exclude jurors on the basis of their race. So they held that the defendant in a criminal trial has the right to make what is now called a Batson challenge. So when the prosecutor says, "Judge, I'd like to strike juror number 10, then the defendant's attorney can say, "I'd like to challenge that because it looks like this is being done on the basis of that juror's race." But the criminal context is a little different than the civil context. How come? Why did we need a whole separate case to go to the Supreme Court? Why didn't Batson just decide the issue that we're looking at in Edmondson versus Leesville? Why would it make such a big difference if it's criminal or civil?
Was that because the civil they didn't have to explain it? And then, so now in criminal, they would have to explain their justification?
In criminal, they did. In civil, they didn't until Edmondson. And the reason is because the Constitution, by definition, limits the government, limits state actors, right? So the prosecutor is a state actor. They are hired by the state, or when we're talking about federal cases, the federal government, right? So when we see Batson versus Kentucky, that's because Kentucky is the state, right? Or People versus O.J. Simpson. The People is the state of California, or United States versus whoever, right? They are a state actor, so they can't violate the Equal Protection Clause of the 14th Amendment because they are acting as the government. But in civil cases, Edmondson versus Leesville, nobody is acting as the government. It is two private parties suing each other. So if you want to make a rule where you say, "I am only allowing women in my house," or "I'm only allowing white people in my house," or "I am not letting anyone in my house say any opinions that are different than mine," you can do that because you are not bound by the First Amendment or the 14th Amendment, right? That's why a private school can say, "We're only hiring Catholic teachers," or "We're requiring a uniform." They don't have to abide by the Equal Protection Clause or the First Amendment, right to freedom of expression, because they're not the government. So when you're on Facebook or X or whatever social media platform, and someone's like, I have the right to say what I want. It's a free country, First Amendment, freedom of speech. They are wrong, because those are private companies and they can have content guidelines. And if you don't adhere to the content guidelines, they can kick you off their platform, right? There is no constitutional right to do whatever you want on social media, because they are not the United States government. On the other hand, if you got in trouble for wearing a t-shirt in Woodward Park that said, you know, I love free thinkers and flower children, then, right, your constitutional rights would have been violated, because that's public property. It's, you know, owned by the city of Fresno, and the city of Fresno is a government actor. Same with if you're on Fresno State campus or Fresno City College campus. And those campuses couldn't say we're only hiring women or we're only hiring Catholics, right? Because they're government actors. So that's why we need a whole separate case to see how this works in the civil context. So the way it works under Batson is, first, we have the peremptory, no reason is given. Then the defendant would have to make a prima facie case by showing, one, the person struck as part of a protected class. So they are either, you know, a member of a minoritized race or gender group or religious group, sexual orientation, etc., right? Depending on how many groups end up getting recognized as protected in this context. And circumstances indicate that that is why the person was struck. So this can usually be like a pattern if they use all of their peremptory strikes against members of this group or a significant portion. Then the burden shifts to the prosecutor to give a neutral or non-discriminatory explanation for this strike. So they might say, no, it wasn't based on that person's race. It was because they were rolling their eyes when I was talking, right? They have to give some other reason. Then the court undertakes a sensitive inquiry into the circumstances to figure out, you know, which party it believes. So does it believe the non-discriminatory explanation, or does it look like it was actually being done on a discriminatory basis? So what if the explanation is, it was just my gut feeling? Is that enough? Without anything else?
No.
No. So it has to be something more than that, but not very much more, right? So the court has held even silly or superstitious reasons, or even things like because that person has a beard, or because of that person's age or their political affiliation. Those things are all okay. So it doesn't have to be a whole lot more. Did somebody have a question?
I did. I was going back to the flower child thing. They
Yeah.
could actually say, I don't like flower children on the
Yes.
jury.
Yeah,
Okay.
they could say because that person's a hippie.
Okay.
Yes.
And that would be an acceptable excuse.
Yes, that would
Okay.
pass muster for the explanation. But let's say they had kept a bunch of other people dressed like hippies who were not that person's same race. Let's say they said, like, they're wearing bell bottoms, and they had struck, you know, a Black person wearing bell bottoms but kept the white people. Well, then they're probably going to have a problem at stage 3. So the explanation's okay, but then when the judge is doing the sensitive inquiry, they might say, well, but even though you gave an okay explanation, it looks like that wasn't really why. But it'll pass muster using that person's like clothing.
Thanks.
Sure. Yeah, so it's pretty easy to come up with the explanation, right? So I linked to a news article, and I'm happy to send this PowerPoint to anyone who's interested, where in 2012 in California, prosecutors struck people who were protesting Prop 8, which was relates to gay marriage based on their sexual orientation, saying I struck this person because they look gay, like in open court giving that, and saying, well, sexual orientation isn't race, this should be allowed. So interesting story about that, if you are interested. So what is needed is not very much. So these are all quotes from actual Supreme Court cases saying that it needs not be minimally persuasive, let alone rise to a challenge for cause. Even silly or superstitious is okay. So it can be something like the presence of facial hair, family background, length of residence. So really not that much is needed. And then step 3, the court will look at the particular a prosecutor, if we're talking about Batson, or party in general's history of using peremptory strikes. They'll look at raw data, disparate questioning. So if they asked way more questions to one set of jurors or no questions at all, it might look like, oh, they were trying to come up with a reason for striking this particular group of people, or trying to ask them nothing so that they wouldn't have to say, they wouldn't have to say any reason except, facial expression. So they'll look into all of these types of circumstances. Brittany, did you have a question?
When you say they look into history of preemptive strikes, is that like your career history or just the history within that case?
They'll look into career history. So in, criminal cases, like with prosecutors and public defenders, they might have a lot more on that than in like a civil case where the party might never have been in court and the lawyer might not have been in court that much. But in criminal cases, there might be, a big history there. Okay, so after Batson gets decided, it gets expanded in several ways. So first, it gets expanded not just from prosecutors, but to defendants in criminal cases. So defendants also cannot strike jurors based on race. That's in a case called Georgia versus McCollum. Then it gets expanded to peremptory challenges on the basis of someone's sex. So it gets expanded to people being struck because they are male or female. Then it gets expanded to cases, they clarified that it's okay for someone to make a Batson challenge, even if they aren't the same race as the juror who is struck. So if, a Latino person wants to make a Batson challenge saying it looks like the prosecutor struck this juror because they're Black, that's okay. They don't have to be the same race. And for our case, we are looking at the expansion of Batson to civil cases. So we went over the facts, but Thaddeus Donald Edmondson was injured on the job. He sued Leesville, his employer, for $420,000 because after his leg was crushed, he was in the hospital for several weeks and he missed work for months. During voir dire, Leesville used 2 of its 3 peremptory challenges to remove Black persons from the prospective jury. We don't know very much about the 2 Black men that it struck because Leesville's attorney didn't ask them a single question. So even though they asked the other prospective jurors a lot of questions, didn't ask them a single thing. Edmondson's attorney, Jim Doyle, tried to make a Batson challenge, but the judge said, no, this is a civil case. Batson doesn't expand to single cases. Leesville doesn't have to give any explanation at all for the strikes. So the impaneled jury contained 1 Black person. They rendered a verdict that said, yes, Leesville is liable, but only 20% liable. And they said he isn't entitled to the whole $420,000. He's only entitled to $90,000. And because he's 80% responsible for the accident himself, he only gets $18,000. At this point, his bills had stacked up. He was still unable to work. He eventually lost his house. He had children, one of whom was starting college. And so he said, even though I technically won, they said Leesville was liable. This isn't acceptable. So he appeals. And the issue on appeal, which eventually, many years later, reaches the Supreme Court, is simply whether a private litigant in a civil case can use peremptory challenges to exclude jurors on account of their race. So there are two sub-issues here. The first is whether excluding jurors based on race in a civil case violates the Equal Protection Clause, given that private people, unlike a prosecutor, don't aren't working for the government, right? That they aren't state actors. And the second is whether Edmondson can raise the equal protection claims of the jurors who were struck, because the idea of standing is that you have to have suffered an injury in order for you to make a claim. And the idea is if there's an equal protection right to serve on a civil jury, then the people who were treated unequally were the jurors who were struck, not Edmondson, because he isn't the person who was struck. So his rights to equal protection under the law haven't been violated. So what does the court say? Anyone who read the excerpt, what do they say about this problem of the private civil litigants making this different than a criminal case? How do they justify imposing this requirement on private actors in civil cases?
If I can remember, it said that once they used the strike, they were acting as a state actor somehow, or they were acting somehow. The government got involved in that one, then it changed to where they have to have equal protection.
Yes, exactly. So first, they give a test where they say, first, the right to use a peremptory at all comes from a federal law, comes from a right having its source in state authority. And they say, in this context, Leesville is acting as a state actor because being on a jury is serving in a governmental function. People are summoned there by the court, they are paid by the court, and they are making decisions that normally a judge would make. But I think the most important thing they say, and I know we're getting a little short on time, so I'm going to jump to what I think is really the heart of this case, is that they say the injury caused by the discrimination is made more severe because the government permits it to occur within the courthouse itself where the law unfolds. So they say, yes, it's an awful thing if you are, in a store and someone treats you in a racist way. But for a judge to enforce that, for them to say, yes, I'm going to honor the strike, now you leave. When you are in a courthouse where justice is supposed to be occurring, where someone is supposed to be getting a fair trial, they are getting their Seventh Amendment right to trial by jury, trying to get redress for an injury they have suffered. They say that is made worse for someone to be standing there with an American flag in the background in a court of law, having a judge condone the racist action. So they say this injury is aggravated in a unique way by the involvement of the judicial branch, by the government involvement. So another case where they found that private people are acting as the state in this similar way is in cases about racially restrictive covenants. So these are neighborhood agreements in the 40s and 50s where whole neighborhoods would say, sign agreements never to sell or lease their house to people of color. And they said, yes, while private people can enter into agreements like that, and they can abide by the terms of them without violating the Equal Protection Clause, courts can't enforce them, because when a court gets involved, then there is a state actor, and that aggravates the injury. So that's a case called Shelley versus Kramer. And this is a picture of the Shelley family who, was purchasing a house. Then someone sued trying to stop the purchase, saying, no, this violates this racially restrictive covenant. And the Supreme Court held, no, even though this is an agreement between private parties, it would be a violation of the Equal Protection Clause for a court of law to enforce the covenant. So they hold the same thing here. Yes, private people can act racistly because they aren't subject to the Equal Protection Clause, but a court is not going to condone it. What do they say about the issue of standing? Do they say that Thaddeus Edmondson is allowed to raise the equal protection arguments of the jurors who have been excluded?
Yes.
Yes, they do. So they go into a doctrine called third party standing. And they say, for one thing, the jurors are not going to raise their own constitutional deprivations, their own injuries, because as any of you know, most people try to get out of jury service. So if you are excused from jury duty, you're not going to go find a lawyer and file a case and wait 10 years till it makes it to the Supreme Court to say your equal protection rights have been violated, even if they have been, because that is daunting, it's expensive. So they say there is a hindrance to those jurors raising their own injuries. And they say, even though Edmondson's equal protection rights weren't violated, his right to a fair trial that isn't marred by racial discrimination, that's been violated. So he's allowed to make these arguments. So because of his tenacity in sticking with this claim for 10 years, the Supreme Court held that in civil cases, people cannot use peremptory challenges based on race. And like in the criminal context, this has also been expanded to include gender as well. Okay, so I know we are at time. So sorry, we were a little rushed there. Normally our class, we would cover this in 2 sessions instead of 1, and they are an hour and a half, but hopefully you got a little something out of this. And if you want to share my email, Diane, I would love to hear from any of you. We are not in session right now, but in the fall, if you are not enrolled and you want to come sit in on a class, I would love to have you. So feel free to reach out to me. But does anyone have last minute questions before I log off?
Just really quickly, back to the case that Georgia versus McCollum, did they make a lot of the arguments that the Supreme Court made, because they expanded it to the defense attorneys using racially based preemptory challenges?
So that's a great question. I would have to imagine they did. If I've read that case, it was in law school, since I don't teach in the, criminal context. But I also think it might've been about like fairness or leveling the playing field, since they'd already expanded it to prosecutors there. But I'd have to imagine they did, because they run into that same, state actor problem there.
Exactly.
Yeah.
Thank you.
Good question, Deanne. Okay, well, I'm going to log off, but Diana's going to stay on. So thank you guys again so much for being here. And I hope to hear from you and see some of you in class either this fall or in the future. So best of luck to
Thank
all
you,
of you.
Dean Tennerelli. That was super interesting.
Oh, thank you, Diane. And I am just going to, do I need to make you host again, or you're good?
I think we're co-hosts, so I think we're good.
Okay, great. Okay, bye.